Shalom, my fellow blood sovereign Hebrew Israelites. I am Akish Faraj, a lion of the tribe of Judah, of the 12 tribes of Israel. I am making this video to make a declaration and proclamation of our true nationality to the whole world, nationwide. The Immigration and Nationality Act, INA, proclaiming that any person who is not a citizen or a national of the United States speaks of we, sovereign Hebrew Israelites, mistakenly identified as so-called Negroes of so-called African descent, involuntarily brought to the United States by means of the historical Atlantic slave trade. According to the curses of Deuteronomy, chapter 28, verses 15 through 68. So-called Negroes, African American, black, colored, etc., are not nationalities, heritages, identities, nor does any of them have a language, and in reality of the real world does not exist. The right to a nationality is of paramount importance to the realizations of other fundamental rights. Possession of a nationality carries with it the diplomatic protection of the country of nationality, and is also often a legal or practical requirement for the exercise of fundamental rights. Consequently, the right to a nationality has been described as the right to have rights. See Trop versus Dulles. That's Trop versus Dulles, 356 US 86, 101-102, 1958. A people that lack a nationality are therefore among the world's most vulnerable to fundamental rights violations, which we can see happening to so-called Negroes, African Americans, black, colored, etc. every day. In recognition of the importance of having a nationality, a number of regional and international human rights instruments include the right to a nationality. Article 15 of the Universal Declaration of Human Rights states that everyone has a right to a nationality, and that no one shall be arbitrarily deprived of his nationality, nor denied the right to change his nationality. See also American Convention on Human Rights, Article 20. The right to a nationality is often articulated through protection of the rights of children and the principle of non-discrimination. For example, Article 7 of the Convention on the Rights of the Child states that every child has the right to acquire a nationality, while Article 5 of the Convention on the Elimination of All Forms of Racial Discrimination requires states to prohibit and to eliminate racial discrimination in all its forms, and to guarantee the right of everyone, without distinction as to race, color, or national or ethnic origin, to equality before the law, notably in the enjoyment of the following rights: the rights to a nationality. 1 Corinthians chapter 6 verse 1 says, "Dare any of you having a matter against another go to law before the unjust and not before the saints?" Meaning, speaking of we Hebrew Israelites going to a Western court system trying to receive justice. Only a Hebrew Israelite can judge another Hebrew Israelite. And because we are waking up as a nation to understand this truth through scriptures, the Most High no longer gives any other nation this authority to judge we Hebrew Israelites. Dred Scott versus Sanford, 60 U.S. 393, 1857, was a landmark decision by the U.S. Supreme Court, in which the court held that no pure-blooded Negro of so-called African descent, whether slave or free, could be American citizens, and therefore had no standing to sue in federal court, and that the federal government, Congress, had no power to regulate slavery in the sovereign 50 states, territories of the United States of America. Dred Scott, a Negro slave of so-called African descent who had been taken by his owners to a free state, attempted to sue for his freedom. In a 7-2 decision written by Chief Justice Roger B. Taney of the Supreme Court denied Scott's request, ruling an act of Congress to be unconstitutional. Dred Scott, according to Roman civil law, was considered a pure-blooded Negro of African descent, in which, if he was living today, would be considered a so-called Negro, African American, black, colored, etc., with a European slave master name, which shall be used throughout this video. As long as Dred Scott considered himself a so-called Negro, African American, black, colored, etc., and retained the European name, Dred Scott, under their Roman civil law, he was the property of his slave owner. And right now, to this day, we are under Roman civil law. And all so-called African Americans that retain their European slave name are slaves, are considered slaves. And as of today, on this date, I, Akish Faraj, of the tribe of Judah, of the 12 tribes of Israel, on behalf of my people, blood sovereign Hebrew, gives a declaration of Israelite American nationality status to the world, nationwide. And I hereby declare that we, so-called African Americans, Negroes, colored, blacks, are true sovereign Hebrew Israelites. Our forefathers are Abraham, Isaac, and Jacob. And according to the Genesis chapter 15, verse 18, and Joshua chapter 1, verse 4, the land the Most High gave to us, the true Israelites, includes everything from the Nile River in Egypt to Lebanon, south to north, and everything from the Mediterranean Sea to the Euphrates River, west to east. The definition of country. By country is meant the state of which one is a member. Every man's country is in general the state in which he happens to have been born. Bavor law. That's Bouvires. 1856, Title 8, USC 1101A21. 1984, U.S. Government Style Manual, Chapter 5.22/5.23, Law of Nations. Country. The portion of Earth's surface occupied by an independent nation or people, or the inhabitants of such territory. Black's Law Dictionary, 4th edition. Country. The territory occupied by an independent nation or people, or the inhabitants of such territory, in the primary meaning of country, denotes the population, the nation, the state, or the government having possession or dominion over a territory. Black's Law Dictionary, 6th edition. A nation/state is a specific form of state, a political entity which exists to provide a sovereign territory for a particular nation, a cultural entity, and which derives its legitimacy from that function. The Compact OED defines it as a sovereign state of which most of the citizens or subjects are united also by factors which define a nation, such as language or common descent. Typically, it is a unitary state with a single system of law and government. It is almost by definition a sovereign state, meaning that there is no external authority above the state itself. Wikipedia Encyclopedia. In regards to the protection of our citizens and their rights at home and abroad, we have no law which divides them into classes or makes any difference whatever between a native or neutralized American may, therefore, go forth with equal security over every sea and through every land under heaven, including the country in which the latter was born. That's 9 OP, U.S. Attorney General, 360, 1859. All 50 states of the Union are nations according to law and hold sovereign rights above any United States government, nation rights. All nationals of these nations/states are sovereign and hold all rights of common law and the organic Constitution. The 14th Amendment created a federal nation as compared to the sovereign state nations, compressed of the 50 sovereign states of the Union. This amendment created a de facto citizenship which every Israelite American became through unwitting acquiescence, thereby placing them under privilege of such citizenship and also allegiance to and subject under the laws to same. Case law supports this premise. Section 1, Clause 1. All persons born or neutralized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Clause 2. No state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States. Clause 3. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 1, Clause 1. All persons born or neutralized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. This clearly creates a de facto dual citizenship status never before existent for the sovereign state national. Dual citizenship definition. The citizenship in two different countries. Status of citizens of the United States who reside within a state. Persons who are born or neutralized in the United States are citizens of the United States and the state wherein they reside. Black's Law Dictionary, 6th edition. Neutralized definition. To grant full citizenship to one of foreign birth. American Heritage Dictionary is the resource. Prior to the 14th Amendment, citizens of the United States meant a citizen of one of the United States of America. However, this was not defined by Congress because this phrase is now used in the 14th Amendment. This sets forth a specific terminology and can no longer mean anything else other than a citizen of the federal government. A United States citizen neutralized as such at birth without informed consent. Previous court case law touched on this de facto entity. The citizen of the United States in Ex parte Frank Knowles, California Supreme Court, July term, 1885. In this case, the court stated that there was no such thing as a citizen of the United States. That is to say, there was no such thing as a citizen of the federal state, only a citizen of one of the United States of America. This section, Section 1, contemplates two sources of citizenship and two sources only, birth and neutralization. The persons declared to be citizens are all persons born or neutralized in the United States and subject to the jurisdiction thereof. The evident meaning of these last words is not merely subject in some respect or degree to the jurisdiction of the United States. but completely subject to their political jurisdiction and owing them direct and immediate allegiance. The case cited is Elk versus Wilkins. That's ELK versus Wilkins, WILKINS, 112 US 94, 1884. The use of the words there and them indicates a de facto power created to be above the Israelite American people, something no Israelite American willingly accepts and no organic law supports. And whereas it is claimed that such American citizens with their descendants are subject of foreign states, foreign to the United States, owing allegiance to the governments of the states thereof, and whereas it is necessary to the maintenance of public peace that this claim of foreign allegiance should be promptly and finally disavowed, preamble of the Expropriation Act. Preamble of the Expropriation Act. Expropriation Act. Case law prior to 14th Amendment passage should indicate no such legal requirement exists, but is what they want all de jure citizens to do. For it is certain that in the sense in which the word citizen is used in the federal Constitution, citizens of each state and citizens of the United States are convertible terms. They mean the same thing, for the citizens of each state are entitled to all privileges and immunities of citizens in the several states. And citizens of the United States are, of course, citizens of all the United States. 44 Maine, 518, 1859. Hathaway J. dissenting, italics in original underlined and C's added. Case law after passage of the 14th Amendment. It is quite clear then that there is citizenship of the United States and citizenships of a state which are distinct from each other and which depend upon different characteristics or circumstances in the individual. That's Slaughterhouse Cases, 83 U.S. 36, 1873. The first clause of the 14th Amendment made Negroes citizens of the United States and citizens of the state in which they also and hereby created two classes of citizens, one of the United States and the other of the state. Corey, E.T.A.L. versus Carter, 48 IND 327, 1874. Head notes 8, emphasis added. We have in our political system a government of the United States and a government of each of the several states. Each one of these governments is distinct from the other, and each has citizens of its own. You see that? Each has citizens of its own. But the African Americans are considered federal citizens, not United States of American citizens. The so-called African Americans. I don't know who that is. I'm not an African American. I'm a Hebrew Israelite, American national. One may be a citizen of a state and yet not a citizen of the United States. Case cited, Thomas versus State, 15 IND 449. Corey versus Carter, 48 IND 327. McCarthy versus Froehlke, Froelke, 63 IND 507. Henry Wells, Wehlitz, 16 Wis, 443. McDonald versus State, 90 IND 320, 323, 1883. We sovereign Hebrew Israelites, de jure American nationals, apply for no such dual citizenship of the insurgent United States de facto government. created about the time of the so-called Civil War, which was actually an international war against the sovereign nation/states of the Union. Apart from or in addition to or natural-born blood sovereign Hebrew Israelite American de jure nationality received at birth. We Israelites reject such de facto citizenship of the United States federal government and return our de jure blood sovereign Hebrew Israelite American nationality of the sovereign nation/state in which we Israelites are decimaled at any given time based on our original blood sovereign Hebrew Israelite American de jure national/state nationality. Law of Nations, Title 8, USC 1101A 21. Section 1, Clause 2. No state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States. This portion of Section 1 clearly defines that such United States de facto citizens do not have natural rights, but are granted privileges for being such a de facto citizen, thereby removing them from de jure status as blood sovereign Hebrew Israelites American nationals of their respective states, including all natural rights such as sovereign would otherwise enjoy. Government does not grant natural rights. It is to uphold them. All naturalized citizens of the United States while in foreign states, one of the several American republics, shall be entitled to and shall receive from this government the same protection of persons and property that is accorded to native-born citizens in like situations and circumstances. Exportation Act, Section 2. The term foreign states includes outlying possessions of a foreign state, but self-governed dominions or territories under a mandate or trusteeship shall be regarded as separate foreign states. Title 8 USC 1101A 14. This is trying to imply that a de facto African American, Negro, black, colored, etc. citizenship slaves of the de facto United States federal government are being given all the same de jure rights that de jure citizens, read non-citizens of the United States, but citizens of de jure states have. But this is not true, as all U.S. so-called citizen, African American, Negro, black, colored, etc. citizenship slaves are under the jurisdictions of the United States federal government and all its Roman civil code of laws. These privileges and immunities are not the same as the ones secured by the Article 4, Section 2 of the Organic Constitution for non-14th Amendment citizens. Citizens are members of a political community who in their associated capacity have established or submitted themselves to the dominion of a government for the promotion of their general welfare and the protection of their individual as well as collective rights. This citizen cannot complain because he has voluntarily submitted himself to such a form of government. He owes allegiance to the two departments, so to speak, and within their respective spheres must pay the penalties. Let me read that again. Let me say that again. Citizens are members of political community who in their associated capacity have established or submitted themselves to the dominion of a government for the promotion of their general welfare and the protection of their individual as well as collective rights. The citizen cannot complain because he has voluntarily submitted himself to such a form of government. He owes allegiance to the two departments, so to speak, and within their respective spheres must pay the penalty. That's U.S. The case cited is U.S. versus Cruikshank. Cruikshank, which is spelled Cruiksshank, 92 U.S. 542, 1875. So what this is saying? So what this is saying is that since so-called African Americans accept being citizens of the federal government and accept federal privileges under civil law, they could be murdered with impunity, without recourse. But our people are destroyed. Like Hosea 4:6, chapter 4, verse 6 says, our people are destroyed for lack of knowledge. And yet all they do is complain. And it just explained that you have no right to complain. So the only way that we could get this right is to come out of this system, to come out of the system like Revelations 4:6 says, come out of her, my people. U.S. versus Kirkenshain gives us reason why blood sovereign Hebrew Israelites, American nationals, in disguise as so-called African Americans, Negro, blacks, and colors, etc., are being murdered with impunity, legally. The citizens cannot complain because he has voluntarily submitted himself to such a form of government. This makes all 14th Amendment state dependencies of the federal government, and as such, colonies of the same. Colonies of the same. Colony definition. A dependent political community consisting of a member of citizens of the same country who have immigrated therefrom to people another and remain subject to the mother country. Territory attached to another nation known as the mother country, with the political and economic ties, possessions, or dependency of the British Crown. See? Dependency of the British Crown. Original 13 colonies of the United States. The Neutrality Act of 1939, preamble, Title 8 USC, and Title 22 USC all set forth two different jurisdictions, the de jure jurisdiction and the Constitution, and the de jure, the de facto jurisdiction under the 14th Amendment. Upon birth under the 14th Amendment rules, all blood sovereign Hebrew Israelite American national disguised as so-called African Americans, Negroes, black, colors, etc. are fictionally by paper birth certificate transported to Washington, D.C., then fictionally by paper birth certificates transported back to the state wherein they reside. This quick change of citizenship is done without knowing approval and by fraud, and takes all blood sovereign Hebrew Israelite American nationals who submit to such out of being a blood sovereign Hebrew Israelite de jure American nationals of the state of their birth and into the de facto residential jurisdiction of the federal government and de facto United States within the several states. If a blood sovereign Hebrew Israelite American national is naturally born into a state/nation, he has not legally submitted to such. We blood sovereign Hebrew Israelite American nationals have not knowingly accepted the neutralized citizenship of the 14th Amendment related to the United States federal government and reject this de facto fraud. Assertion government definition. The tyrannical assumption of the government by force contrary to and in violation of the Constitution of the country. Bavor Law Dictionary, 1856. The United States federal government has accomplished this through legal fraud, deceit, and blood sovereign Hebrew Israelite American nationals' unwitting acceptance of the same through ignorance. We Israelites no longer wish to rebel against our nationality, our Hebrew Israelite nationality, or nation/state, and accept the de jure national and common law jurisdiction which resides with the blood sovereign Hebrew Israelite American national nation. We are sovereign and independent, sojourners, live, breathing, flesh and blood Hebrew Israelite American national men and women, not having allegiance to the United States corporation structure, nor to federal jurisdiction, and not to state jurisdictional powers, not afforded to it by the organic Constitution. Sojourner's definition: one who has all the rights to which a free individual is entitled, one who is not under the power of another as a slave, a minor, and the like. Bevor's law. Sojourners: everyone of full age is presumed to be sojourners of full capacity, in his own right capable of entering into a contract. Valentine's Law Dictionary. In common usage, the term person does not include the sovereign. Statutes employing the word person are ordinarily construed to exclude the sovereign. Wilson versus Omaha Tribe, 442 U.S. 653, 667, 1979, quoting United States versus Cooper Corporation, 312 U.S. 600, let me say that again. The case cited is State versus Cooper Corporation, 312 U.S. 600, 604, 1941. See also United States versus Maine Mine Workers, 330 U.S. 258, 275, 1947. Supreme Court case quotes. The idea that the word person ordinarily excludes the sovereign can also be traced to the familiar principle that the king is not bound by any act of parliament unless he be named therein by special and particular words. Dollar Saving Bank versus United States, 19 Wall 227, 239, 1874. As this passage suggests, however, this interpretive principle applies only to the enacting sovereign. United States versus California, 297 U.S., 175, 186, 1936. See also Jefferson County Pharmaceutical Incorp. Versus Abbott Laboratories, 460 U.S. 150, 161 in 21, 1983. Furthermore, as explained in United States versus Heron, 20 Wall 251, 255, 1874, even the principle as applied to the enacting of sovereign is not without limitations. Where an act of parliament is made for the public good, as for the advancement of religion and justice, or to prevent injury and wrong, the king is bound by such act, though not particularly named therein, but where a statute is general and thereby in prerogative, right, title, or interest is divested or taken from the king. In such case, the king is not bound unless the statute is made to extend to him by express words. A sovereign is exempt from suit, not because of any formal conception or absolute theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. That's Kawanaka. That's Kawanakaoa versus Polyblank, Polyblank, 205 U.S. 349, 353, 27 S CT 526, 527, 51 L edition, 834, 1907. The majority of American states fully embrace the sovereign immunity theory, as well as the federal government. See reinstatement, second of torts, 895b, comment at 400, 1979. We blood sovereign Hebrew Israelite American nationals shall have occasion incidentally to invent how true it is that state and governments were made for blood sovereign Hebrew Israelite American national men and women, and at the same time how true it is that his creatures and servants have first deceived, next vilified, and at least oppressed their master and maker. A state definition, useful and valuable as the contrivance is the inferior contrivance of a man, and from his native dignity derives all his acquired importance. Let a state be considered a subordinate to the people, but let everything else be subordinate to the state. The latter part of this portion is equally necessary with the former, for in practice and even at length in the science of politics, there has very frequently been a strong current against the natural order of things, an inconsiderate or an interested disposition to sacrifice the end to the means. As the state has claimed precedence of the people, so in the same inverted course of things, the government has often claimed precedence of the state. And to this perversion, in the second degree, many of the volumes of confusion concerning sovereignty owe their existence. The ministries dignified, very popular by the appellation of the magistrate, have wished and have succeeded in their wish to be considered as the sovereigns of the state. So in other words, the government has switched from the people being sovereign to the government being sovereign. In other words, the government does not owe allegiance to the people, but the people owe allegiance to the government. This is called reverse psychology. Whereas the people, the judges, the attorneys, the police are all public servants to the people. But yet we the people believe that with their authority, they have authority over us. When it's reverse psychology. We the ones have the authority over them. So we got to get it right. We got to change this. The second degree of perversion is confined to the old world and begins to diminish even there. But the first degree is still too prevalent even in the several states of which our union is composed. By a state, I mean a complete body of free persons united together for their common benefit, to enjoy peacefully what is their own, and to do justice to others. It is an artificial person. It has its affairs and its interests. It has its rules. It has its rights. And it has its obligations. It may acquire property distinct from that of its members. It may acquire debt to be discharged out of the public stock, not out of the private fortunes of the individuals. It may be bound by contracts and for damages arising from the breach of those contracts. In all our contemplations, however, concerning these feigned and artificial persons, we should never forget that in truth and nature, those who think and speak and act are men. Is the foregoing description of a state a true description? It will not be questioned, but it is. It will be sufficient to observe briefly that the sovereignties in Europe, and particularly in England, exist on feudal principles. That's feudal principles. That system considers the prince as the sovereign and the people as his subjects. It regards his person as the object of allegiance and excludes the idea of his being an equal footing with a subject. either in a court of justice or elsewhere. That system contemplates him as being the fountain of honor and authority, and from his grace and grant derives all franchise, immunities, and privileges. It is easy to perceive that such a sovereign could not be amenable to a court of justice or subjected to judicial control and actual constraint. It was of necessity. Therefore, that stability became incompatible with such sovereignty. Besides the prince having all the executive powers, the judgment of the courts would in fact be only monetary, not mandatory to him, and a capacity to be advised as a distinct thing from a capacity to be sued. That same feudal ideals run through all their jurisprudence and constantly remind us of the distinction between the prince and the subject. No such ideas obtained here. Speaking of America, at the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects, unless the African slaves among us, the so-called African slaves, may be so-called, which they are so-called. Let me read that again. No such idea obtained here. Speaking of America, at the Revolution, the sovereignty devoted on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects, unless the African slaves among us may be so called, and have none to govern but themselves. The citizens of America are equal as follow: citizens and as joint tenants in the sovereignty. That's Cushom versus Georgia. That's CHISHOLM versus Georgia. February term, 1793. U.S. 419, 2 Dale, DALL, 419, 1 L, edition 440. Meaning that since we call Negroes or whatever they want to call us, we have no if you want to call yourself so-called African Americans, you have no rights. You have no rights. It's all an illusion. It's all an illusion. Man, I don't know what to say to you, my people, other than you must start listening to what I'm trying to say here. And we must set it right. We must come together and as a nation of Hebrew Israelites in front of these people who are deceiving us. The individual may stand upon his constitutional right as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no such duty to submit his book and papers for an examination to the state, since he receives nothing therefrom. So if you stop receiving benefits from the state or from the federal government, they have no authority over us. Beyond the protection of his life and property, his rights are such as exist by the law of the land, common law, long antecedents to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. That means as long as we don't harm anyone, the government has no rights to question us or to do anything. Only if you decide to continue to be a so-called African American, a Negro, black, and colored, and give them authority over you. This is, again, my people, this is why we're being murdered with impunity, because you give them the right to murder you. You accepting their benefits, and you have no recourse, you have no reason to complain, as stated previously. Our blood sovereign Hebrew Israelite American national rights of exportation from the United States federal government into nationality for recovery of our de jure blood sovereign Hebrew Israelite. Beyond the protection let me see. Oh, wow. This is something else. This is something else. Let me read this all over again. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no such duty to submit his books and papers for an examination to the state, since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by law of the land, common law, not civil law, common law, long antecedent to the organization of the state, and can only be taken from him by due process of law, and in accordance with the Constitution. Among his rights are refusal to incriminate himself, and the immunity of himself and his property from arrest or seizure, except under a warrant of law. He owes nothing to the public so long as he does not trespass upon their rights. That case cited is Hale versus Hinkle. That's H-A-L-E versus Hinkle. H-E-N-K-E-L. 201 U.S. 43 at 47, 1905. Our blood sovereign Hebrew Israelite American national rights of exportation from United States federal government nationality for recovery of our de jure blood sovereign Hebrew Israelite American national several United States nationality is covered in Title 8 USC 1481 A and Title 8 USC 1502, which we, the true elect of the 12 tribes of Israel, hereby declare and hereby proclaim. B'Shem Yeshaya HaMessiah Ahav Meshiach and Rorak, the Holy Spirit, proclaim. Shalom.